Hey everyone, welcome to Question Period Rewind. I'm Donna Skelly, the Speaker of the Legislative Assembly of Ontario. Get ready to travel back in time to 1986, the year when Microsoft went public, the Oprah Winfrey Show was first syndicated, and when Wayne Gretzky was at the top of his game with the Edmonton Oilers, breaking his own NHL record for the most assists and the most points in a season. These are records, by the way, that he still holds to this day. Now, let's take a listen to what the House was talking about.
Oral questions. The Leader of the Opposition.
Mr. Speaker, my question, Mr. Speaker, is for the Premier. Premier, you confidently predicted that the passage of Bill 94 would somehow end the strife in the health care system. We have learned this morning that 3 hospitals, York, Finch, Humber, and Northwestern, are going to close shortly, thus indicating not a reduction but an escalation in the action taken by the doctors to protest your action on Bill 94. Could you tell us today what now you propose to protect the care and safety of the people of Ontario?
Premier?
Well, Mr. Speaker, I'm not sure I'd agree with my honourable friend that I've confidently predicted anything in this whole discussion. But, Mr. Speaker, you'll be aware of the discussion we've had. I'm not, very frankly, aware of the information that the honourable member brings to the House at this moment. You may know something that I'm not aware of, but I'll certainly look into the matter and at the first available opportunity.
Supplementary?
Well, Mr. Speaker, through you to the Premier, the OMA released this information a couple of hours ago. The 3 major hospitals in metropolitan Toronto were going to close and stop admitting patients today or tomorrow. Are you now telling this House that having created this chaos in the system, you come to this House 3 hours after this information was made public and tell us that you are not aware of these dangerous circumstances about to occur in metropolitan Toronto?
Premier?
Mr. Speaker, if you'd asked me, I could give you an up-to-date list of everything that's happening at the moment, to the best of my knowledge, as of 1:30 today. As you know, the Ministry has been monitoring the situation carefully with emergency plans in place. And if you're interested in knowing what I know at this moment, I'd be very happy to share the information with you.
Final supplementary?
Well, it is quite evident, and Hansard and electronic Hansard will show that 3 hours after information became public about 3 major hospitals in metropolitan Toronto about to close, the Premier of this province, charged with ensuring the safety and care of the people of this province, did not have that information and was not prepared to respond to it. My question to the Premier is this. You've got a list in front of you of your up-to-date list of what is happening. There is obviously a lot more happening that you don't have and are not aware of. My question today is, what steps are you going to take now to ensure the health and safety of the people of Ontario?
Premier? Mr. Speaker, as you know, when the closings or the partial closings of emergency started a week or so ago, or I guess before that, there are emergency plans in place for every one of those institutions. We have followed those and tracked those on a daily basis in this House. The information is shared here. It's been shared in the newspapers as well. The Ministry is on top of that on an hourly basis. As you know, this government, the Minister, and I have not indulged in speculation about what may or may not happen, but there has been a plan in place. And I can assure you that the Ministry will be very much on top of this situation. If there's something that I'm personally not aware of, then I apologize to my honorable friend, because I don't pretend to know all the information from hour to hour. But I am confident the Ministry is, and There's a number of discussions going on, as you know, at the present time at a number of levels, and we hope to find a resolution of this matter in the very near future.
New question.
I say to the Premier, it is not sufficient to apologize for not knowing what's going on in the system. The chaos was created by the events of last week. Your minister is up here daily telling us that it's only an inconvenience and not to worry, everything will sort out. And this afternoon, your government is not aware of the closure of hospitals and has no idea of how to respond. My question to the Premier is this. Given that Bill 94 has now passed, and given that at this too late date, you're trying to hold out an apparent olive branch and talking through the Attorney General of cooperating in a court challenge, are you prepared today to announce, together with that court challenge, the appointment of a mediator and the installation of a moratorium period in order to get the doctors back to work while the court challenge is on?
Premier?
A number of things. In response to my honourable friend's question, I guess the reason I wasn't aware of the suggestions that you made in this House is because that's not what, in fact, has transpired. No hospitals have closed, and I don't think you want to create that impression inadvertently in this House or anyone else. They are admitting, as I understand, no new elective patients, but as you try to characterize this, the hospital's closing, it just isn't the case. So, I think we should know that. Number two, you have asked me to appoint a mediator, and I have had discussions with Dr. Railton this morning, as I did on Friday last. I hope to meet with him in the very near future to discuss the situation. As you know, a number of issues have been raised in this discussion. Questions of liberty, questions of doctor-patient relationships, and other things that, frankly, we did not feel were in Bill 94. Bill 94 dealt with one issue and one issue alone, and that was extra billing. But given the fact that the medical profession has raised a number of these concerns, I can assure you, as I assure them, that I'm prepared to sit down and subject these matters to independent review, to the consultation process, to work with them as very best we can in the circumstance to satisfy some of the concerns that they have raised that are not in the bill, but they think may or may not happen sometime in the future. And the third question you asked me is about when the bill will become law. It became law on Friday, as you know. It was received royal assent and was proclaimed on that day, and I think it would be unfair and indeed inhuman to deceive people in any way as to the intentions of the will of this House.
Supplementary?
Just, Mr. Speaker, to clarify the record, I indicated that it had been announced that those hospitals will close and will stop admitting patients, not that they already had. Now, I should also clarify, Mr. Speaker, that we did not suggest the bill had not become law. To bring this back to reality, I want to ask the Premier this. Given his attempt to be reasonable and moderate, would he not now agree that it would be advisable, in order to stop the escalation of activity, for him to indicate when he next speaks to Dr. Railton that the Premier is prepared to have a moratorium on enforcement of Bill 94 pending the court action if the doctors will return to work?
Premier?
I'm not sure what my honourable friend finds so offensive about being reasonable and moderate. I don't think it's a bad posture in these circumstances, and perhaps he can even look at that approach himself. Secondly, we intend to be fair but flexible in the implementation of this. As you know, as of Friday, it is illegal to extra bill in this province, and any patient that is extra billed will be reimbursed. It might take some time to work out the bookkeeping systems from the various doctors that extra bill at the present time. Believe me, we'll work with the doctors to implement it in their own particular ways, given their own bookkeeping system. So we have no problem being fair-minded at all turns.
Final supplementary?
I want to tell the Premier what I find offensive about his suggestion that he be reasonable and moderate. And let me say I do find it offensive to hear you talk about that, because it is like a drunk driver who has killed someone in an automobile accident calling up the family of the victim and saying, "I'd like to come over and chat with you to assure you that I will not drink and drive again, and I will not run over or kill your other children,
Final
and I promise to
supplementary.
be good from now on." In fact,
Order.
it is
Order.
your unreasonable and immoderate activities that have caused this situation.
Final supplementary.
Now, I want to give the Premier...
Order. 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 Final supplementary, please.
When you finally got around to criticizing
Final
him, your leader said it
supplementary.
was just rhetoric. Just rhetoric, he said. Terrific.
Order.
My final...
Order. 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 Final supplementary.
Look what you've created in the province.
My final supplementary to the Premier is this. Given the fact that we now have all sorts of problems in the healthcare system, would he not agree that the appointment of a mediator to try and bring a new presence to the table, given the enormous ill will that has been created between the government and the OMA, would now be an appropriate response to try and get the doctors back to work?
Premier.
With respect to my honourable friend's preamble, I think it's fair to say we all have our own standards of what's offensive, and I would say that your analogy would be judged offensive by most people observing what you've said today. So, with respect to your second point,
Order.
I'm very happy to answer it. We have suggested on Friday last and sometime before that we should look at some of these questions with respect to health care delivery in conjunction with someone of say, the independent credentials of a Dr. John Evans. And we have hoped that, for example, we have put forward specifically that idea as one in conjunction with the OMA drafting the terms of reference and participating in those discussions can assist in addressing the very questions that you raise here. These are not new questions, Mr. Speaker. These are old questions. They've been around for a long period of time, and as I'm sure the honourable member opposite will know, this government is prepared in all occasions to face up to its responsibilities and try to deal with these things and not sweep them under the rug. And if those are concerns of the medical profession, I assure you we are prepared to sit down with them and deal with them in an honourable way.
New question, the member for York South.
Mr. Speaker, I'd like to ask the Premier, given the announcement today...
Ask for his resignation like you did on Saturday.
...that there are 3 hospitals that were informed this morning by their staff that they would be withdrawing from emergency services indefinitely and that no more elective patients would be admitted. I'd like to ask the Premier, is it his view that the doctors who so informed the staff of the 3 hospitals in question, the Humber Memorial Hospital, the Northwestern General Hospital, and the York Finch Hospital, is it the view of the Premier that those doctors, in so advising those hospitals, acted in conformity with the law of the province of Ontario?
Premier.
To my honourable friend, I'm not very frankly in a position to give you a legal opinion on that matter. And the answer, I guess, is I don't know. But I think that the college, obviously, will be looking at this situation, and pending better advice than I have at the moment, then I'm not in a position to say whether that is legal or illegal. Obviously, it was my fondest hope that we could stop this kind of response from the medical profession at the moment. As you know, and I repeat to you, they are not closed. The hospitals are not closed. They are just not admitting elective patients, as they have not been since the withdrawal of services. So there is a very serious difference in terms of the terminology.
Order. Order. Supplementary.
Mr. Speaker, by way of supplementary, I referred earlier in my comments about the Attorney General's statement today that the public really does not know, because the Premier does not know, and the Attorney General has not stated what the law of the province of Ontario is. I'd like to ask the Premier, since the college has today said, similarly, we understand that our society accepts as a legitimate form of protest the right of groups to withdraw their services with resultant public inconvenience in order to promote certain changes or results considered beneficial to the group interest. I'd like to ask the Premier, is that the government's view with respect to the action that's being taken by the doctors? And if it's good enough for the doctors, then why isn't it good enough for the nurses? And why isn't it good enough for the dietary aides? And why isn't it good enough for all the other people who are working in what the government has up until now deemed to be an essential service, that is to say the public hospitals of the province of Ontario?
Premier?
My understanding is that the college has said that to close down a hospital would be deemed to be professional misconduct. Now, they are the adjudicators of that matter at the present time. You raised questions in your question to me of the broader public policy implications of this situation, and you talked about the difference of treatment of the staff as opposed to the medical profession. Those are perhaps legitimate questions to be raised at some point in the future, but I say to you that I don't think it's constructive at this moment to start in a public discussion of those matters when we have the situation that we have. And so as these, I'm sure, and as this thing unravels, that we will discuss all of the issues that have been raised during this discussion.
Final supplementary?
Mr. Speaker, I think we're entitled, I think the patients of the province are entitled, as well as the doctors and everyone else and all the other partners and parties in the system, to know just what rules we're playing by now, just what is acceptable and what is not acceptable. What is it that's lawful, what is it that's not lawful? I'd like to ask the Premier in that regard. In an earlier statement, the College of Physicians and Surgeons said, and I quote, "It is unacceptable to have a serious disruption of emergency capabilities in referral or tertiary care institutions." Now, the Premier will know that that's code language for hospitals that are, in fact, teaching hospitals, and that are providing what is deemed to be, even by the college, to be a more essential service than that which is being provided by Humber or Northwestern or any other regionally based hospital. I'd like to ask the Premier, can he explain why the college has so far said nothing about the closure from time to time of Mount Sinai and of the Wellesley Hospital, both of which qualify under this category? And can he tell us why the college has said nothing? And if he can't tell us, does he not recognize that the system of telling the patients what the law is, telling the public what the law is, and telling the profession what the law is, that system has now broken down and something needs to be done to reestablish it very clearly for everybody?
Mr. Speaker, my honorable friend, as a highly trained lawyer, will understand that it's one thing to have a statement of the law, as you have read to us, and it's another thing to apply that and interpret it vis-a-vis the facts of a particular situation. And I'm sure that my honorable friend would not want to prejudge these situations in a very sensitive situation. I say to you that the college has had a great deal of pressure on it from both sides, and you're very much aware of that as well. I think they've made a very clear statement of their principles. Now the question is the application of that law to the specific situation. But one of the problems in this whole discussion, sometimes there's an oversimplification of the terms used. People use the word like closed when it isn't in fact closed. And that's why I think it behooves us all to look at the fact situation very, very carefully before we generalize or constitute ourselves as a court of inquiry in this matter.
New question, the member for the member for Ottawa Centre. New question.
Thank you, Mr. Speaker. My question is to the Minister responsible for women's issues. The Minister will be aware that there was a press conference held this morning by the Equal Pay Coalition, the YWCA of Metro, Canadian Union of Public Employees, the Ontario Public Service Employees Union, the Business and Professional Women's Clubs of Ontario, the Coalition of Visible Minority Women, and the Ontario Federation of Labour, all to ask this government to table legislation governing equal pay for work of equal value in the private sector. Is the Minister now prepared to do that?
Minister.
The timetable I provided a couple of weeks ago remains the timetable that the government intends to utilize.
Supplementary.
Mr. Speaker, I'd like to ask the Minister if he's aware that even the union which stands to benefit from the very limited coverage that will be provided by Bill 105 for what is called the public sector is now saying that it does not wish to be isolated from the rest of working women in Ontario. How does he respond to their request that the legislation now be tabled and that they don't want to be used by the Liberals as a false symbol of equal pay in Ontario?
Mr. Speaker, as the Minister of Labour has said, Bill 105 will, in due course, I think shortly be debated at second reading, and the views of unions and other persons who may be expected to come within that bill can be canvassed either by the House or the committee to which the bill is referred. The timetable for the private sector bill remains as I stated it to be. That is to say, we will introduce a bill in the next session following the completion of the studies that are being done at the present time.
Final supplementary.
Mr. Speaker, the minister knows that the studies that he's created for the summer period are not necessary to the announcement of the legislation or indeed to the announcement of the principles of the legislation for equal pay coverage. Will he tell us how he expects his government to have credibility on this issue when in fact the longer we go on, the more we know that women's rights are being compromised?
Mr. Speaker, I believe that at the end the credibility of the government on this or indeed any other issue will be judged by the result of the bill that we produce. We want to produce the best possible bill in the circumstances of the case. I cannot say and would not dare say that the studies that are proceeding this summer would not change anybody's mind. The purpose of having studies, of course, is to form as thorough a view as you can about a subject matter before a decision is taken. You don't have studies after conclusions in order to fortify your own views about what is right.
New question. Order. New question, the Leader of the Opposition.
My question, Mr. Speaker, is for the Premier. With an invitation to deal directly with the real problems faced by patients whose surgery has been canceled, whose beds will not be available for them at York, Finch, Humber, and Northwestern hospitals today, tomorrow, the next few days. I wonder what advice the Premier now has to offer those people whose surgery is canceled. Is his advice that it's only an inconvenience and they shouldn't worry? Is his advice to call the Ministry of Health, which will tell him in turn to call their doctor or go to emergency? What precisely should the patients in this province do given this horrendous circumstance which you have created?
Premier?
My advice to those patients in the circumstances would be to speak to their physicians and say to the physicians, look, I understand you have a difference of opinion with the government, but I would hope you wouldn't take it out on me personally. I hope you would assist me as my doctor because I trust you and within your medical judgments. And I would hope that the patients would be able to persuade doctors that they could deal with them in a professional way, and the other outstanding differences they have with the government, they could come back and hopefully work it out with the government, but not to carry those resentments or those difficulties into their professional relationships with their clients and patients, and that's the advice I would give the patients.
Supplementary.
Mr. Speaker, through you to the Premier. The Premier has, one way or another, with his colleagues, so agitated, so irritated the medical profession over the last few months that those calls, whether you like it or not, whether I like it or not, to their doctors are not resolving the problem. The surgery's being canceled. The hospitals, use your word, will not schedule any more surgery. Because of the situation you've created, the arrogance and the irritation that you've shown towards the doctors, those calls are not getting the patients looked after. Now, my question to the Premier is this. Given that the solution you recommend clearly won't work and it hasn't worked for 12 days, are you now prepared to help these struggling patients get their surgery by saying to the OMA, look, let's cool it off, let's have a mediator, let's postpone the implementation of the bill, and let's get the surgery done so as to get rid of the disorder. And let me say, Premier, it's more than inconvenience. It's a dangerous situation
Premier.
out there.
This is the same question the honourable members asked me about 3 or 4 times today, and I will give him the same answer. We are very happy to sit down with the profession. I've told you, I've talked to Dr. Railton today. We hope to get together very quickly my hopes and ambitions, we could put in place a mechanism to start addressing some of the problems that the medical profession has raised. Now, if my honourable friend is standing up and recommending a legislation of some type or other, then he should stand up and say so. You know, you can't have it both ways in this whole discussion. I think the Minister has been very steady on course in this matter. I think we've been open and conciliatory on this matter, and I can tell you we're advancing exactly the way we said we would.
New question. Order. New question, the member for York South.
Speaker, I have a question for the Attorney General. It concerns the subject of abortion. The Attorney General will know that a number of hospitals have, in fact, shut down their therapeutic abortion committees. And there are widespread press reports that we can only assume are reliable, as well as reports from the 2 clinics that are performing abortions, that in fact a number of referrals are coming from these committees and these doctors to those private clinics. Since the Attorney General, Mr. Speaker, has already told the press that what these doctors tell their patients to do is none of his business and none of anybody else's business, I wonder if the Attorney General can tell us today what his intentions are with respect to the doctors who are now performing therapeutic abortions at the freestanding clinic.
Mr. Speaker, the answer to that requires a little preamble. As the member knows, the question of where and under what circumstance an abortion can be performed is a matter of federal law, and the law provides that an abortion can only be performed in Canada in a hospital after approval by a therapeutic abortion committee according to the standards that the law sets for that committee. An abortion performed anywhere else or under any other circumstances in Canada is unlawful. It is unlawful if it is performed in your home, if it's performed in an office, or if it's performed in a clinic. Mr. Crosby, the Minister of Justice, has indicated plainly on a number of occasions, and he alone and his government are responsible for the federal criminal code, that they do not propose to change the law at the present time that makes abortions performed at home, in an office, or in a clinic unlawful. The solution to women's problems, which are very real, will not be served by having therapeutic abortions done contrary to law in the province.
Supplementary.
Like in the province of Quebec. I'd like to ask the Attorney General, he will know that the defense that has been used successfully in the province of Quebec 3 times, and that was used to the satisfaction of the jury in Ontario, the only time it's been charged, was the defense of necessity. Would the Attorney General not agree that that defense can only be strengthened by 2 things? First of all, the fact that a number of therapeutic abortion committees are now closed, and referrals are now being made by doctors who are practicing medicine in the province, right across the province, who are now referring patients to those clinics. And second of all, is strengthened by the refusal of his government to deal with the question of access, to deal with the problem of the number of therapeutic abortion committees that are closed, and to deal with the reality that women simply cannot get service under the system as it now stands in the province of Ontario.
Mr. Speaker, the honourable member is correct if he refers to an acquittal by a jury. That, of course, is what happened. What the Court of Appeal said, unlike the ultimate situation in the province of Quebec, was that there had not been a trial according to law, and they directed a new trial with which we have undertaken to proceed with that trial when the appeal to the Supreme Court of Canada is finished. The solution for access for women to those places in which alone an abortion can, in accordance with law, be completed, is a medical question. And the colleagues of the Minister of Health have made representations to him about that issue. But it is no solution to say that the problems of women are to be responded to by creating operations which can only occur outside the law. I put my position this way. We believe that access to abortions must be achieved within the context of law. We therefore cannot condone the establishment of illegal clinics. Those aren't my words. Those are the words, reading the Caucus Party Committee of the New Democratic Party on Abortion, of Jim Renwick, whose judgment I respect in this matter.
Order. The member for Downsview.
Mr. Speaker, I have a question of the Minister of Labour. I wonder if the
Minister of Labour can bring this also up to date with regard to the status of striking workers in the Children's Aid Society. I've had a number of phone calls, and could you bring us up to the point where you now perceive the current situation?
Minister?
Well, I thank the honourable member for that question. The House will know, Mr. Speaker, that the Metro Children's Aid Society strike began a week ago last Friday, and after the employees voted to of the Children's Aid Society voted to turn down the last offer, the mediator, Mr. Speaker, has stayed in close contact with the party since the walkout began, and there are indications, Mr. Speaker, that the parties may get back together sometime later this week, perhaps as early as Wednesday. But I want to advise the honourable member so that he can tell his constituents, Mr. Speaker, that Mr. Lapp is in close contact with both parties in the dispute, and we're hopeful of seeing some real progress in the next short while.
Supplementary?
By way of supplementary, Mr. Speaker, I'd like to ask the Minister if he sees any possibility of an early settlement with regard to the strike.
Minister?
Well, Mr. Lapp, I'm advised that the mediator, Mr. Speaker, has been in contact, as I said, with both of the parties, and that earlier today indicated that it may be fruitful to get back to the bargaining table in the next short while. Obviously, we're hopeful that when mediation resumes, that we will move rapidly to a settlement and hopefully put this dispute behind us.
New question, the member for Lincoln.
Thank you, Mr. Speaker. Questions to the Premier. It follows on the questions of the member for York South. You'll now know that 5 therapeutic abortion clinics are without medical advisors. There have been resignations from five hospital clinics. That is not a narrow-based problem. It's a problem that's right across Ontario, in Brampton, in Burlington, in Kitchener-Waterloo, in Sarnia, as well as Metro Toronto. Abortions are being cancelled, no new cases are being scrutinized, and women are being denied access to this important health care. What are you going to do about this problem of health care inaccessibility?
Premier?
Speaker, we are certainly trying to persuade the doctors to return to their normal responsibilities in this regard, and we understand, and we know the press reports, but we understand that things are carrying on in the hospitals.
Supplementary?
Mr. Speaker, the Premier and his government has spoken on many occasions about improved access for women to therapeutic abortions. Now you face a situation where your policies have meant that access has been reduced. Access for some women has been eliminated. I say to you again, what are you going to do to provide this essential health care to the women of Ontario?
Premier?
Speaker, I'm interested in my honourable colleague's new position on behalf of your party. It's interesting to know. But let me say this. We are concerned now, as we were concerned a year ago, that everyone in this province should have equal access to quality medicine everywhere in the province. And that's why we brought in programs like Northern Travel and a lot of others to make sure that people don't suffer being in one region or the other. This is one aspect of that, Mr. Speaker, and I can tell you the ministry is looking at this matter very seriously, and I think you'll see some results with respect to equal access everywhere in this province.
New question, the member for Riverdale.
Mr. Speaker, I have a question for the Minister of Housing. There are 2 bills on the order paper waiting to be called that relate to housing. There's Bill 11, which purports to protect the rental housing stock, and there's Bill 51, which purports to protect renters. Can the Minister explain to the House why both Bill 11 and Bill 51 create 2 classes of tenants in this province, those that live in buildings of 6 units or more, and those that live in buildings of 6 units or less?
Minister?
Mr. Speaker, both bills, and as a matter of fact, the assured housing policy that was introduced tried to address all tenants in this province. And both bills tried to address some concerns that some inequities were being experienced. The bill is not intended to differentiate different or to separate different tenants. It is a matter to bring equity to all tenants in the province.
Supplementary.
By way of supplementary, Mr. Speaker, the minister says that he is creating equity for all tenants, but his executive assistant is quoted in today's Globe and Mail as saying at some point you have to draw the line. I'd like to ask the minister why he would draw a line that leaves the tenants of 446,000 units on the wrong side of a line that offers them no protection from eviction because of demolition and offers them inadequate protection from illegal rents.
Minister.
Mr. Speaker, if the honourable member wants to be completely fair about it, you are including, my dear honourable friend, even single units of 127,000. Are you saying that we should restrict people from converting in single units? You speak about 400 and odd units that are not being protected. Mr. Speaker, those 6 units and more are where the bulk of the activity of conversions and demolitions and evictions are being concerned. And we have concentrated in that area, Mr. Speaker.
New question, the member for Brampton.
My question to the Minister of Community and Social Services. I'd like to inquire, during the currency of this strike, how are the services through the society being performed?
Minister.
Children's Aid Society.
Referring to the Toronto Children's Aid Society, and at the present time 130 management workers from the society are meeting the needs of the children who have the most urgent needs.
New question, the member for Brantford.
Thank you, Mr. Speaker. I have a question for the Premier regarding your technology fund grant of $17.5 million to the Exploricom project. My question is this, Mr. Premier, I have here a financial planning summary from Exploricom dated the 21st of April of this year, which indicates very clearly that $17.5 million would be forthcoming to the project from the Government of Ontario. My question to you, sir, is this. In view of the fact that this document predates the throne speech, which announced your technology fund, predates the budget, which announced the funding for the technology fund, and accurately predicts to the last penny the amount of the grant, could you tell me, sir, whether your friend Mr. Schwartz is a clairvoyant, or did he have inside information that $17.5 million was coming his way?
One of the things that's quite obvious to you and everyone else is that Mr. Schwartz is a very, very bright fellow, else he would never have been able to bring a project like this to fruition. Now, you'll recall, Mr. Speaker, that the application was originally in 1984, and it went up through the bowels of the ministry. I'm not sure if the minister saw it or not. And it was reviewed by this government. As a matter of fact, the Committee of Deputy Ministers decided, I believe, on March 27th that it should be in the throne speech and funded through in the budget and throughout. So it had all these checks along the way. Now, I can't tell you the specific date of that situation, but I assume that was the amount that was in the original application.
How did he know? Thank you, Mr. Speaker.
Supplementary.
Thank you, Mr. Speaker. In fact, the original submission for this program, which did come out, as the Premier indicated some time ago, was completely different. The funding amounts were all different. It even had a different name, the Canadian Computer Museum. And so I go back to the original question, sir. Before you announced that your government was going to institute a technology fund, before you announced the amount of funding that you would be putting into that fund, 5 weeks before you announced the grant going to Mr. Schwartz's project, he confidently projects to the last penny a $17.5 million grant from the Ontario government. Now, I ask you, this is the 3rd week we have asked for you to table documentation in this House surrounding this application. Will you now clear up that there was no inside dealing and no inside information in the award of this grant? Because I tell you, Mr. Premier, the appearance is very substantially to that effect.
Premier.
My honourable friend asked very legitimate questions, and my understanding is the information will all be tabled tomorrow. And as you've raised some of these questions about how these grants are made, we've looked into a number of other grants, and we'll share all the information with you, the approval process that has gone on in this government and in your government, and I think it's something that should be looked at. And I think you'll want to call the Committee of Deputy Ministers that made this decision on March 27th, and then passed it on to the Cabinet, and I think my friend opposite will find some very interesting reading in the whole matter.
New question, the member for Bellwoods.
I have a question.
Order.
Time for a wink.
Order. Once again, interjections are out of order. 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 The member for Cochrane South. Order. New question, the member for Bellwoods.
Thank you, Mr. Speaker. I have a question for the Minister of Labor concerning the behavior of the Workers' Compensation Board at the leading case which is being heard by the Workers' Compensation Appeals Tribunal, the case of Mario Villanucci. Can the Minister explain two things to the House? Why the Workers' Compensation Board appears to have given false information to the tribunal with respect to one of the doctors who examined Mr. Villanucci. First, they said he had been retired from the board, where in fact he was working full-time for the board. Then they said he was too sick to appear, where in fact he was working full-time, making claims and pensions decisions. Can he explain why the Compensation Board stonewalled for 3 days against Mr. Villanucci's request to call Workers' Compensation Board doctors to testify as witnesses?
Minister.
Well, Mr. Speaker, I think that the honourable member knows those at the board well enough, and knows their reputation well enough to know that any problem, and there may be a problem here, was simply an oversight. It is not the intention, Mr. Speaker, of the board in this very important case to stonewall at all. The matter is an important one. The board acknowledges it. We acknowledge it. I'm sure the honourable member, in raising these questions on this very important test of Section 45(1), realizes that these cases are far too important to get into that kind of a situation. I'm sure that the board will cooperate as fully as possible with the Workers' Compensation Appeals Tribunal as this matter moves forward.
Well, I agree with the Minister that this case is too important to allow it to be sabotaged by the Workers' Compensation Board. So I want to ask you by way of supplementary, will you agree to meet with the chairman of the board of the WCB and report back to this House the position of the WCB with respect to the appearance of doctors at the Villanucci hearing, specifically whether or not the Workers' Compensation Board will voluntarily agree to allow its doctors to testify at the Villanucci hearing without restriction and without the threat of challenges in higher courts?
Minister.
Well, Mr. Speaker, the challenge, the threat of challenge, as I understand it from this morning's press, came from the chairman of the tribunal. But I'll be pleased, Mr. Speaker. There have been already some discussions in this matter. I'm sure the honourable member knows that that the appearance of the board of doctors in this case would be, in terms of the historical precedents, would be quite unusual. But I'd be pleased to discuss this matter, Mr. Speaker, with Dr. Elgee, in the hope, Mr. Speaker, that this matter can move ahead just as quickly as possible.
The Minister of Consumer and Commercial Relations has a response to a question previously asked by the member for Welland Thorold. Minister.
On June the 4th, the member for Welland Thorold asked me a question re the go-kart insurance for Seabrook's Delmar Drive-In and Campground in Ironbridge, Ontario. Members of my staff, Grant Swanson of our insurance department and Al O'Donnell of our market assist team, have been in contact with the Seabrooks who operate the go-kart track in question and have been working to help them find insurance. Mr. O'Donnell informs me that insurance is available for the Seabrooks through Do So and Associates, providing that the go-kart operation meets certain underwriting requirements. Mr. O'Donnell understands that with some modifications, the Seabrooks operation can meet those requirements. This insurance would not have any participant exclusion. The Seabrooks have been told about this option which is available to them. Also, the Ontario liability insurers have provided the Seabrooks with a quotation for insurance which is limited in that it has a participant exclusion.
New question, the member for Brantford.
Question for the Minister of Industry and Trade. Mr. Minister, in the throne speech, which describes, or at least to the extent that we have any knowledge of the Technology Fund, it says, and I quote regarding the Technology Fund, that the Council will direct monies to business, universities, and colleges by way of shared financing. Would the Minister clarify the impression left in that statement that, in fact, the grants made by your Technology Fund will be made on a matching dollar basis with other sources of financing?
Minister.
Thank you, Mr. Speaker. It is hoped, to the member, it is hoped that the technology people, being part of the Technology Committee, will be meeting very shortly in the first part of July, and some of those decisions will be made at that time.
Come on. Supplementary.
I wonder, Mr. Minister, if when the Council finally meets and makes some of these decisions, will they retroactively be setting the criteria for the Exploracom grant that was announced some weeks ago, clearly in the absence of any funding criteria, application procedure, council, or anything else?
Minister.
Mr. Speaker, as the Premier mentioned, that material will be tabled tomorrow, and the information will be there for you.
New question, the member for Welland Thorold.
Yes, I have a question to the Minister of Consumer and Commercial Relations. Sure, he'll be aware that last week Herbert Phillips, the chief actuary of the Insurers Advisory Organization, stated that liability insurance rates were up 63% in the first quarter of this year, and that auto insurance rates, he said, and I quote, "There's every likelihood of 30 to 40% increases in Ontario this year." Mr. Minister, as a minister responsible for insurance and insurance rates in this province, simply will you tell this House whether these levels of increases are justified?
Minister.
Mr. Speaker, I thank the member for his question, and I should correct him. I am not responsible for the insurance rates in this province, with one exception, and that is the Facility Association. The speculation in the press that the rates may go up is just that, speculation. You will know that we are looking into the whole aspect of insurance. We're waiting for public response to the Slater Committee by July the 31st, and then we will be reacting to that.
Supplementary.
Well, given, Mr. Minister, that you've just refused to assure this House that these kinds of increases are justified, and also refused to even consider a public system like that in the western provinces where there have been no increases, would you not admit that sections 369 to 371 of the Insurance Act would give your ministry the power to control and limit premium increases? Why don't you get out of the insurance company's pocket, say enough is enough, proclaim those sections, and limit increases in the second year of massive hikes to the inflation rate?
Mr. Speaker, I'm going to repeat again for the member, and I've repeated to him for some time, we are looking at all aspects of the insurance business, but at this time we are certainly not looking at getting into the insurance business.
New question. The member for York West.
Thank you very much, Mr. Speaker. In the absence of the Minister of Health, I'd like to direct my question to the Premier. As currently drafted, pharmacy bills 54 and 55 threaten consumer rights because they encourage pharmacists to substitute interchangeable drugs when filling prescriptions without having to inform consumers. Does the Premier agree that consumers should be told in advance by pharmacists whenever a prescribed drug is being substituted with an interchangeable product, and that consumers have the right to know and choose what they are getting? And Mr. Premier, would you guarantee consumer rights in the final legislation?
Well, Mr. Premier. Speaker, we've had a very full discussion in this House on the matter, and I gather the discussion will continue, and you'll have a perfect opportunity to put forward all your very thoughtful views at that time.
Supplementary?
Mr. Premier, just want to remind you that...
by way of supplementary, I hope.
Yes, it's a supplementary, Mr. Speaker. That currently in the present legislation, we don't have those guarantees for the consumers in this province. Bill 54 requires that pharmacists supply the lowest cost list drug for the elderly and welfare recipients under the Ontario Drug Benefit Plan. The bill is currently drafted, denies consumers the right
supplementary, please,
to pay the price difference between the lowest cost drug and the drug prescribed by the doctor. Now, will the Premier assure this House that final legislation will allow seniors and those on welfare the right to choose and pay the price difference if they wish, or will they be forced to swallow the pill the government tells them to?
Premier?
Speaker, we never make anyone swallow bitter pills on this side of the House, Mr. Speaker, and I appreciate the newfound advocacy for the consumer of my colleague opposite, and I know that he will want to take advantage of the discussion in this House to put forward his views on behalf of the people of this province, because that's who we're fighting for all of the time, the consumers, the people of this province, and we're glad to help you join us.
New question, the member for Oakwood.
Thank you very much, Mr. Speaker. Mr. Speaker.
Order. The member for Oakwood would like to ask a question.
My question is for the Minister of Education, and it's regarding the arbitration board decision in the matter of the Heritage Languages program. The Minister knows that the arbitration board, in the dispute between the Toronto teachers and the Toronto board, has decided what the New Democratic Party has known for years, and what the Conservative, the Tories, have always refused to accept, namely that the heritage languages must be integrated during the school day. Will the Minister tell us what steps he intends to take to ensure that children, ethnic children in our elementary schools, would no longer be segregated, ghettoized, and treated as second-class students? Specifically, will the Minister now move to change the Education Act so that community languages can be taught during the 5 hours of the school day?
Minister.
Mr. Speaker, the interest arbitration in this matter, which was handed down late last week, made clear that boards of education have the right to exercise the option to offer the heritage language instruction in the regular day. The arbitration was quite clear and strong in that, and of course, ministry regulations provide that as an option to boards. The actual delivery of the program, as the honourable member knows, is and has been thus far a matter of local board option. We as a government are strongly supportive of the heritage language program, and recognizing the interest that this interest arbitration has generated and the debate that has taken place around the subject, particularly here in the City of Toronto, but elsewhere in the province. I am at the present time reviewing ministry policy. I've taken note, for example, of the honourable member's Bill 80, which he tabled last week in the House, and I hope later this summer to be able to share with him the results of my thinking with respect to the interest arbitration and other input that I will be receiving in this very important area.
Supplementary.
Well, I want to. I want to say to the.
By way of supplementary, I hope.
By way of supplementary to the Minister of Education, that certainly I hope his opinions is not changing from back in 1978, when he said into this legislature in debating this very same bill that sometimes we were given too much in this place to the Connaughts. I think it is time we really took a look and asked why not. I feel the direction of this heritage language bill is a very positive step and an important one.
Supplementary.
Now, as a supplementary, doesn't the minister realize that exactly the ghettoization that the arbitration board talks about is the reason that the heritage language program was set up, in terms of the memorandum of back in 1976, when it says that such classes may be offered after school or in no school days, or where numbers justify an extension of the required 5-hour school day. My question is,
Order.
will you do it?
The question's been asked. Minister?
Mr. Speaker, what has not changed is my commitment, or this party and government's commitment, to the very important heritage language programs that have been developed throughout much of Ontario, now in 73 school boards, funded to over $10 million by the Ministry of Education. We as a party and as a government are strongly committed to heritage language instruction. But perhaps, Mr. Speaker, we differ with the honourable member and his colleagues in this connection. We intend, in this matter as in other matters, to do so in a cooperative and collaborative way, recognizing the important role that local boards and teachers have in the delivery of this very important and positive part of education.
New question. The member for Sudbury.
A question for the Minister of Housing.
Order. Point of order. I had risen to ask a question.
I'm very sorry. I was looking in the wrong direction. The member.
Mr. Speaker, I have a question for the Attorney General. Mr. Attorney General, you've set up a hearing by Mr. Justice Zuber of the justice system. I'd like to inquire as to whether or not his terms of reference will also include the updating of the rate for small claims courts throughout this province, as opposed to the testing periods where they've been held thus far.
Minister.
Mr. Justice Zuber is certainly entitled to consider that matter. As the member knows, the government is committed to extending the jurisdiction of the small claims court. The problem is that it costs somewhere between $10 and $15 million to do so, and the government is considering where on its list of priorities this matter should in fact lie.
Order. New question, the member for Sudbury.
Speaker, a question for the Minister of Housing. Last week you confirmed once again in this legislature that there was some kind of magic formula that is in your new bill, Bill 51, that will mean that tenants living in buildings that have chronically depressed rents, that they will have some protection while the rents go up to 7.2% next year. I wonder if you would take the time to take that bill that I just sent over to you, which is your bill, and would you kindly open that bill and indicate on what page the formula is and explain it to us?
Minister?
I think we got this question last week.
Mr. Speaker, I know the member would like me to read along with him, and I don't think the House itself, Mr. Speaker, would give me the time to assist him reading along with him with Bill 51. I've also, Mr. Speaker, as you may have seen by now, prepared a guide for proposed Residential Rent Regulation Act. It is done, Mr. Speaker, in order to assist the member to understand the bill.
That's right.
Again, Mr. Speaker, he asked that question on numerous occasions about this chronic depressed rents. I offered not only that, and I tried to give him an answer in here. If he did not understand, I went further, Mr. Speaker. I offered to him the legal advice of my staff to sit down with him, and he still did not understand it. What I'd like the member to do, Mr. Speaker, is to get Bill 51 read in the House a second time. I'd also like him to prepare himself to pass this bill and to make any amendments he wants in regards to this bill. And any suggestion, and if he feels if he's not comfortable with the manner and the formula that will be put forth in dealing with those chronic depressed rent, I think he has all those opportunities to do
Supplementary.
Well, Speaker, I consider that answer to be a very arrogant answer. Last week in the House, you held that guide up, that very guide up you had a minute ago, and you said, oh, no, the formula's not in there to me. And today, you can't even pick that formula out of the bill, which is your bill, and yet you indicated last week that formula was in the bill. Now, either you know there's a formula or you don't. Secondly, when are you going to tell us what the formula is, and are you going to protect those tenants?
Minister?
Susan, help them out, will you? Help them out. Help them out.
Okay, Mr. Speaker,
My goodness. Order. Order. Minister?
Mr. Speaker, if you allow me, Mr. Speaker, in the short time that we have, I will then read it to him. Hardship relief. He asked me, Mr. Speaker, to read it to him.
Just a very brief reply.
I hope so. There are two types of hardship relief. Page 35. Now, I'm going to help you with a guide. It's much easier for you, Mr. Speaker. There are two types of hardship relief for a landlord. Hardship relief and chronically depressed rents. On the hardship relief, if a landlord is making a profit which is less than 2% of his total revenues, rent review can allow a rent increase which allow the landlord 2% more than his total cost. Are you with me still, Honourable Member? Now go on. In other words,
Go with it, Jim. Go with it.
if a landlord total costs are $100,000 and his total rent revenues are $101,000, rent review can allow his total rent revenues to increase to 102.
Order. 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 I didn't call for a supplementary. New question. The member for Algoma.
Mr. Speaker, I have a question to the Minister of Northern Development and Mines in regard to a letter that was sent to him from the Stanley Black, the Vice President of